Hello, good evening, everybody. Good evening. Happy Sunday. Welcome in. Good to see you. Hello. Hello. Hi, James. Hi. Hopefully, everyone's having a lovely Sunday. Hello, Miss Julie. Hello, Kaya. Good to see you. Max, good to see you. Hello, Lisa, Suze. Welcome in, everybody. Oh my gosh, do I have a treat for you tonight? Oh my goodness. Oh my goodness. Hello, Kristen. Yes, Cynthia. Well, hello. I'm doing very well. Thank you very much. Jennifer, good to see you. Good to see you. So, this is just a really interesting set of transcripts, everybody, for tonight. Yes, popcorn is appropriate, I think. So, poor Judge Mershon. I tell you, he's done a pretty good job. Hello, Cecilia. He's done a really good job, I think, overall with this trial. But this was just too much for anyone to have to deal with. So I think he had just had enough by the time we got to this point. So he's it's very, very interesting, everyone. Oh my goodness. So tonight, everyone, I will be reading through Mr. Costello's testimony. Now, his testimony actually wasn't that long, but kind of the shenanigans that went on surrounding his testimony took up quite a bit of time. So, really, thanks for letting me know, Kristen. I appreciate that. Yes, so we're pretty good. I think the language I read through. I try to read through the transcripts a couple of times just to make sure that we're good to go for the community guidelines. So we should be good for tonight. But it's quite the ride. Okay, yeah, I know, me too. Oh my goodness, it's very interesting. So I'll go ahead and break it down for you. We have, as we go through the transcripts here tonight, we've got a wonderful picture here. We've got some great sketches, and I'll be coming back to those. Oh, Mr. Cohen, such a sad Mr. Cohen here. Hello, Desert Skies. Welcome in. So let me kind of break it down for you here, what I will be taking you through. I've got brief proceedings, and I think this is important. We're going to talk about why Mr. Costello was even called. So there is this relationship between Mr. Costello and Mr. Giuliani. So the first part of the transcripts are this proceeding that they have with the attorneys talking with Judge Mershon. The jury is not in the room, and they're kind of going through that. So I think that background is very helpful. And then we will get into, again, that's, I think, very important. And then we will dive into Mr. Costello's testimony. Now, as we all know, during part of his testimony, the judge has some things to say. So, and then at the end of his testimony, when we get to the final piece of it, they do have a few more discussions, but we have a cross-examination, which is done just very masterfully. And so she does a great job, Miss Hoffinger, on cross. And then I don't think we have any redirect. I think Mr. Bove was ready to move on. So no redirect, but then everyone is allowed to leave. And then we have kind of some wrapping up comments here. So that's my hope, is to make it through these transcripts for tonight. Now, we do have some discussion about the jury instructions, or as they're calling it in New York, the charges to the jury. And so those I will read, but not tonight. I just don't have enough time tonight. But I will go through those at a later point. But this is very interesting dynamics here, where we've got this attorney fella who is just absolutely being inappropriate in court, and the judge calls him out on it. So it's a very interesting situation there, everyone. So bear with me. We will have a few pages here of kind of explaining what the relationship is in order to figure out why Mr. Costello's here even to start with, and then we will get into his testimony. And then as we go through it, it takes a very interesting turn. So yes, Costello, who's on first? Exactly, born to bark, exactly right. So stay with me here through this first little bit, and then we will get into his testimony. So welcome, everybody. Welcome. I will go ahead and just dive right in. I do want to make sure I get through this entire testimony tonight, and I don't think there will be a problem doing that. So I'll go ahead and jump in. Hello, H. Titus. Welcome. I knew nothing about him either. Exactly. I had no idea what was going on. So, and no idea why he would have been called. So that's why I think it's important to kind of go through this very first part. So we will be starting on page 4213 here, and this is the proceedings, again, where they are going to be discussing him coming up to the stand. We'll start with the state of New York's prosecutor, Ms. Hoffinger, discussing her perspective on it, and we'll go back and forth a little bit. And this, again, takes place right before, hello, Mads, welcome. Takes place right before he does start testifying. So I will just pick up right here with Ms. Hoffinger, and we're going to kind of just jump in midway through this discussion that they're having at the bench. So, the general rule is extrinsic evidence by way of witness testimony is not permitted on collateral matters. My understanding is they're calling him purely on matters of credibility with respect to Mr. Cohen. The general rule is you can't admit the witness on credibility. You're stuck with the witness's answer. In the alternative, if what they're doing is saying there are some prior inconsistent statements, meaning that Mr. Costello is going to offer 2 prior inconsistent statements by Mr. Cohen, the testimony would be limited just to those 2 statements. I say 2 statements because I've taken a look at the transcripts. And there are only 2 questions where Mr. Cohen said he didn't recall. That was the extent of it. Everything else, he admitted each and every question that Mr. Blanche put to him with respect to Mr. Costello. We don't think Mr. Costello's testimony should be admitted, but if it is, it should be limited only to those 2 statements. Mr. Bove, we respectfully disagree. This testimony is being offered in part to admit prior inconsistent statements through the testimony, but more importantly, it's being offered to rebut the government's theory of a pressure campaign by President Trump in 2018. We moved prior to trial to preclude that evidence. It came in, we understand. So we're offering this as a significant part of our defense to rebut the suggestion from Mr. Cohen that his interactions with Bob Costello were some kind of way for President Trump to get to him to apply pressure. That was the general thrust of his testimony. He said that in specifics. They offered emails about this, so Mr. Costello is going to explain his relationship with Michael Cohen from his perspective to rebut the government's theory on this issue. This is really about Michael Cohen's state of mind. That's the purpose of what you admitted it for, which is why he didn't tell the truth for a very long time. He said repeatedly he did not tell the truth to Mr. Costello. At no time did he tell him why. Hello, Stephanie. Welcome. So Your Honor said that evidence would not be permitted for a consciousness of guilt for Mr. Trump. What we're talking about here is Mr. Cohen's state of mind, and you ruled that was admissible for that purpose. Then defense counsel. Our position, and we're seeking to bring this out through the testimony of Mr. Costello, is that Mr. Cohen lied about his interactions with Bob Costello, and he lied about his state of mind in this time frame, and that he very much wanted to be in touch with Rudy Giuliani, to put questions to the president, to try to extract information about the investigation. This is very much a rebuttal of what the government believed before they opened was an important part of their case. And it also goes to the credibility of the star witness. And it's admissible for all these reasons. I understand, I would expect with any witness, we take it question by question to some extent. Generally speaking, our theory of admissibility is to rebut this pressure campaign concept and to put into evidence that whatever is being said today about Mr. Cohen's state of mind, what he said was his state of mind in 2018 was false, because Mr. Costello will say it's false. Mr. Cohen admitted he reached out to Rudy Giuliani. What it's being admitted for is to rebut the credibility of Mr. Cohen. It's not admissible for that purpose. He's not entitled to elicit opinion testimony about the credibility of Mr. Cohen. We should have discussed this before. I'm going to excuse the jury. Whereupon the following proceedings were held in open court. So the jury is dismissed so they can go on with this conversation. I apologize. I'll ask you to step outside for a few minutes. Again, I do wish we had discussed this earlier. People, let me hear your objections, your concerns. Again, this is just an ongoing discussion on whether or not Mr. Costello can even testify. So the state is saying, sure, Your Honor, again, to say that Mr. Costello, it appears, is being brought in to provide extrinsic evidence to rebut a witness's testimony on collateral matters, and the general rule is that you're stuck with the witness's answer on those matters that affect solely credibility. To the extent that defense is offering statements by Mr. Costello as prior inconsistent statements of Mr. Cohen, then we would say if his testimony is admitted, which we believe it should not be, if it's admitted, it needs to be limited and restricted only to those prior inconsistent statements. They're not entitled to elicit from Mr. Costello his opinions about Mr. Cohen's credibility. They should be restricted just to the two questions, frankly, that Mr. Cohen testified that he didn't recall. All he said was that he didn't recall. He didn't recall Mr. Costello telling him in the first meeting that he could or should cooperate against President Trump. He didn't recall the words saying that he didn't, that he said to Mr. Costello he had nothing on President Trump. But you will recall that he testified several times that he did not tell the truth to Mr. Costello. He absolutely did not tell the truth. He knew it would get back to Mr. Trump through Mr. Giuliani. So I think there's very little testimony that would be permissible, if at all. Giuliani. So I think there's very little testimony that would be permissible, if at all. I did notice days ago of our intention to put Mr. Costello on. There's no mystery here. What we're seeking to do is to counter that evidence. I'm not going to elicit Mr. Costello's opinion of Mr. Cohen's credibility. I'm seeking to elicit many facts about the way that their engagement worked between April of 2018 and the summer of 2018 that bear on things that Mr. Cohen said. For example, he said, I never agreed to retain them. This issue about I was concerned that I couldn't say things because it would get back to the president. The idea that Mr. Costello was pestering him instead of it being the other way around. All these issues, we didn't bring it up. We didn't think this should be admissible. They brought it up. Now we're seeking to offer evidence to respond to an argument they made in their opening, and they put it through Mr. Cohen. In terms of prior inconsistent statement evidence, what I expect Mr. Costello to say is different from what Michael Cohen said. What Michael Cohen suggested is that he sat at the Regency Hotel at this meeting with Mr. Costello and Jeff Citron and omitted information because he was concerned if he had said certain things that they would get back to the president. That's not Mr. Costello's recollection of the conversation at all. What Mr. Costello recalls is Mr. Cohen saying President Trump did not know about the payment to Stephanie Clifford. That's extremely probative at the core of issues in this case. It's not collateral at all. It goes to the heart of the government's theory. So both in terms of evidence of prior inconsistent statements that we will be offering through Mr. Costello, that's somewhat limited, and also, I think more importantly, to rebut the government's pressure campaign theory. That's why this testimony is admissible. You know, I understand the objections. You don't think the pressure campaign theory is collateral? Not at all, Judge. They didn't just ask the guy a question about this. They put in exhibits and they asked how the relationship went. This whole purpose of this was to make President Trump sound threatening, to make it sound like he was interfering with the investigation. I don't think so. I think the reason for it is to explain why at one point he said one thing and at another point he said something else. That doesn't go to the elements of your defense. It doesn't go to your client's guilt or innocence necessarily. It goes to the credibility of Mr. Cohen. Judge, for the government to be suggesting, they're basically suggesting that it includes through that tweet in, I believe it was April of 2017, that they juxtaposed against email traffic with Mr. Costello. The government suggested to this jury that President Trump was tampering with this witness. That is their theory of what the pressure campaign was. They elicited from Mr. Cohen how he felt about these things as they're going on. How can Mr. Costello testify as to what Mr. Cohen felt? He can't. He can testify about what Mr. Cohen said and what Mr. Cohen did. There's many, many examples at this trial where even witnesses who were not a party to a communication were allowed to offer a lay witness opinion. For state of mind, yes. So, in that sense, the witness's opinion is admissible with respect to Mr. Cohen's state of mind, in the same way it's admissible with respect to any other time. I disagree. Mr. Costello can testify to Mr. Cohen's state of mind. I'll consider some of your other arguments. I disagree with that. Mr. Costello can testify what he understood communications to be. That's all I'm saying. In the same way, many other witnesses at this trial have done. I think you have our point at this point. The only other piece is that rebutting the so-called pressure campaign, which, as Your Honor knows, that was not our purpose in putting this in. It was for Michael Cohen's state of mind and why he didn't tell the truth for a long time. Rebutting the pressure campaign should be a part of their direct case. It's not impeachment. They didn't put this witness on their witness list as a direct witness. We didn't get, for example, exhibits that we're supposed to get. We got them recently in terms of Mr. Cohen, and they might use them with Mr. Costello too. We heard this morning he was coming. They let us know a couple of days ago he might. That's direct, not impeachment. The question is whether he's allowed for prior inconsistent statements. I suggest anything else, retainer agreements, whether he paid him, or anything else that's lateral or collateral, he shouldn't be testifying to that. If it's a prior inconsistent statement, his attention should be drawn to the exact statement, and his testimony should be limited to that. Mr. Bove, part of what Mr. Costello is going to do is to explain that certain things that Cohen testified about at this trial were false. Things like Cohen's testimony that there was never an agreement, even verbal, that Mr. Costello would represent him. Things like that, where Mr. Costello is providing direct evidence of perjury at this trial are never collateral, Judge. That's what we're seeking to lay out. It's entirely collateral, Your Honor. That he committed perjury is collateral? I'm going to take 5 minutes. Don't leave the courtroom. Whew. Whereupon the court exits the courtroom. Here we go, everyone. Again, we are right at the beginning, right before Mr. Costello's testimony here. Whereupon the court resumes the bench and the proceedings continue. So, Mr. Bove, you can definitely cross-examine as to the two prior inconsistent statements, obviously, and I will give you some latitude to explore the pressure campaign so you can elicit some inconsistencies so you can offer some rebuttal of Mr. Cohen's testimony. But I'm not going to allow this to become a trial within a trial as to whether or not there was, in fact, this pressure campaign and how it affected Cohen. That's not the purpose of this trial, and I don't want it to become that. As far as the retainer issue, that's collateral. We don't need to go into it. We don't need to go into that at all. Okay, all right, let's get the jury, please. Oh, John, thank you so much. Oh, that was cute. Should we get the witness first, Judge? No, the witness has not yet been sworn in. All rise, jury entering. All right, everybody. So we have to keep in mind, because of this discussion now, there are going to be a lot of objections from the state. Because she has a very narrow scope of what this testimony should be. So I think that was a very interesting piece here. So again, we will dive into his testimony and then things kind of do take a turn. Oh, thank you, Mimi. All right, everyone. Here we go. You may be seated. Case on trial continues. All members of the jury are present and properly seated. Counsel, please call your next witness. The defense calls Robert Costello. Ready for the witness, Your Honor? Yes. Witness entering. Watch your step. Thank you. Remain standing. Raise your right hand and face the court clerk. Robert J. Costello, a witness called on behalf of the defense, having first been duly sworn and examined, and testifies as follows. Yes, get the popcorn out, everybody. Oh, my goodness. Thank you. State your full name, spelling, your last name. Robert Costello. That's awfully loud. Robert J. Costello. Spell your last name. Costello. Please give your county of residence. County of residence is Nassau County. You may inquire. Thank you, Judge. Good afternoon, Mr. Costello. Good afternoon. Where do you work? I'm sorry. Where do you work? I'm a partner in a law firm of David Doff, Hutcher, and Citron. How long have you been at that firm? About 7 years. And prior to your work at that law firm, did you have some government service? I did. When approximately was that? 1975 to 1982. And describe your service for the jury, please. I was an assistant United States attorney in the Southern District of New York, right down the block. I was in 81 and 82. I was the deputy chief of the criminal division there. And so you were a federal prosecutor in Manhattan, right? Yes, I was. Do you know somebody named Michael Cohen? I do. When approximately did you meet Cohen? I met him exactly on April 17th of 2018. Did you meet with him in person that day? I did. Where was the meeting? At the Regency Hotel in Manhattan, and I was accompanied by Jeff Citron, one of my law partners who knew Mr. Cohen. Now, did you consider your conversation at the Regency Hotel that day to be subject of the attorney-client privilege? Objection. Sustained. Absolutely. Objection. Sustained. Can that answer be stricken? And the answer is stricken. Who was at the meeting at the Regency Hotel? Michael Cohen, Jeffrey Citron, and myself. Did the topic of potential cooperation come up? Yes, it did. What was discussed? Well, first, Michael Cohen explained his situation because I had never met Cohen before, so I had no idea what was going on, that his home and his law office had been searched pursuant to a search warrant. And he was absolutely manic at the beginning and throughout the 2 hours of that meeting, marching back and forth, pacing. We were in a conference room on the second floor of the Regency Hotel, and he kept on pacing back and forth, left and right, while myself and Jeff were seated. And after he explained what was going on, he said, "My life is shattered. My family's life is shattered. I don't know what's going to happen." I said, "I really want you to explain to me what my options are. What's my escape route?" That's the phrase he used. So was cooperation one of the options that you described in response to that question? Absolutely it was. What did you tell Mr. Cohen that day? I explained to Mr. Cohen that when he described the search warrants, I pointed out that a search warrant of a law office is much more difficult to get than a search warrant of any other place. Objection. Sustained. What was your view that day about whether or not Michael Cohen should cooperate? Objection. Sustained. What instructions did you give Mr. Cohen with respect to cooperation? Okay, I explained to Mr. Cohen that it was obvious that he was not the target of the search by the Southern District of New York, that they thought he had committed some crimes. Objection. Sustained. I just want to stay narrow on the topic of cooperation and the instructions that you gave Michael Cohen. Okay, I explained to Michael Cohen that this entire legal problem that he was facing would be resolved by the end of the week if he had truthful information on Donald Trump and cooperated with the Southern District of New York. And what, if anything, did Michael Cohen say about President Trump at that point in the meeting? He made the same statement that he made about 10 or 12 times that day, quote, "I swear to God, Bob, I don't have anything on Donald Trump." Did the topic of Stormy Daniels come up? It did. What, if anything, did Cohen say about Stormy Daniels during the meeting? Objection, Your Honor. Overruled. You can answer. He began by saying, "I don't understand why they're trying to put me in jail for some effing NDAs, which is a non-disclosure agreement." Then he said, "I did an NDA with Stormy Daniels." So I asked him to tell me about what the circumstances were, how he was involved. Objection, Your Honor. Sustained. Can you strike that answer? The last answer is stricken, yes. Did Mr. Cohen say anything about President Trump in connection with Stormy Daniels, part of the conversation? He did. Objection, Your Honor. Sustained. May I be heard, Judge? No. Please continue. Did President Trump's family come up? Yes, it did. What did Mr. Cohen say about President Trump's family? Objection, Your Honor. Sustained. Please approach. At sidebar. Mr. Steinglass would like to be heard. Thank you. Respectfully, this is exactly what you just told him not to do. If he's going to be impeaching Mr. Cohen by prior inconsistent statement, the law is extraordinarily clear on this. The witness's attention has to be specifically called to the prior inconsistency, and he has to be given a chance to explain it. Only if he maintains the inconsistency or he says he doesn't remember is impeachment by a prior inconsistent statement by a collateral witness permitted. There were 2 instances where that happened. One Mr. Bove just covered. We are going way far afield of that. This is not a general. Everything that Mr. Cohen testified, did he tell you something different? Did he tell you something different? Did he tell you something different? He would have had to confront Mr. Cohen with those inconsistencies and say, did you tell Mr. Costello X, Y, and Z on this date? And then Cohen would have had it denied. And then it would be permissible. It is not permissible to have a wholesale of everything that Mr. Cohen said. That's not what I'm trying to do, Judge. I'm trying to get to specific statements that Cohen made that President Trump did not know about the payment to Stormy Daniels, which is not, well, why don't you just get to that? I'm trying, because right now what's happening is you're asking these questions and he's going off and he's telling a story, and I'm going to sustain the story. May I lead him then? May I lead? Just get to the question that you want to ask. One question you have, one question you've already gotten to. There is only one more. That's it. Sidebar concluded. A quick side note, everyone here. The reason why he's asking to lead is he's asking to treat him as a hostile witness so he can flip his style of questioning. Now back to the direct examination. Mr. Costello, we are still focused on April 17th and the 2018 meeting at the Regency, and I want to focus very narrowly on whether Cohen said anything about whether President Trump knew about the payment to Stormy Daniels. Yes. What did he say about that specific topic? Michael Cohen said numerous times that President Trump knew nothing about the payments, that he did this on his own, and he repeated that numerous times. Was Rudy Giuliani discussed at this meeting? Objection! I will allow it. You can answer. His name came up very briefly, just in the fact that I had been a student assistant of his back in the early 70s. Other than that, we didn't discuss him. I would like to bring up Mr. Burnick, Government Exhibit 203, into evidence. Do you see this email? I do. And is this email that you sent to Mr. Cohen 2 days after the meeting on April 19th? That's correct. Why did you send this email to him? Because it was announced that day in the newspapers and on TV that Rudy Giuliani was joining Donald Trump's legal team. And if we could take a look now at the context around the email by bringing up Defense Exhibit B1003 into evidence, and let's start by zooming in at 6:45 p.m. Right, I see it. Now, that's the same email we were just looking at, correct? It is, yes. And now let's look at Mr. Cohen's response at 7:36 p.m. Do you see where Mr. Cohen wrote back to you, have great news for Rudy? Yeah. What did you understand that to mean? Objection. Sustained. Do you see where Mr. Cohen wrote, I have been working with lawyers all day? Correct. What did you understand him to mean? Objection. Overruled. You can answer. He was working with McDermott, Will, and Emery, a Washington law firm, and they were going over the evidence that had been seized pursuant to the search warrants, and presumably they were selecting documents that might be claimed to be attorney-client privilege or work product privilege. Did Mr. Cohen say anything to you about not being able to retain you because he had retained the McDermott firm? Objection, Your Honor. Sustained. Not directly, he complained. Sustained. Objection, Your Honor. Sustained. Can the answer be stricken from the record, Your Honor? That answer is stricken from the record. When I sustain an objection, you don't need to answer it. Did there come a time when there was a conversation about retaining you between you and Cohen? Sure, many times. I would like to focus on the period of around April 19th and 20th of 2018. Do you remember a conversation about retention? Objection, Your Honor. Not off the top of my head. Well, what do you recall about this general topic? Objection, Your Honor. Sustained. The issue was, objection, Your Honor. Sustained. I'm sorry. Move to strike it. The answer is stricken. Now, if we could take a look at Government Exhibit 204 in evidence, please. If we could take a look in on the email, the header, please. Right, I see that. Now, this is a message that you sent to Michael Cohen on April 21st, right? That's correct. And do you see the subject line? It says Giuliani. Yeah, Giuliani, right. And in the message you wrote, I just spoke to Rudy Giuliani and told him I was on your team. Yes, I did. And Cohen instructed you to do that? He did. Do you see at the end of this email where it says, he said thank you for opening this back channel of communication and asked me to keep in touch? Yes. Is that term back channel, is that a term that Mr. Giuliani used? Yes. Objection. Sustained. Move to strike, Your Honor. Stricken. What had Michael Cohen said to you about how to communicate with Rudy Giuliani? He told me that I was authorized to tell Giuliani that my firm was, quote, on the team. That's the phrase that he used, but he wasn't going to announce it publicly. So although I could tell Giuliani and Giuliani could tell anybody else associated with the president, he wasn't supposed to tell the media, and that's why he used the term back channel. And were there some times when, objection, Your Honor, overruled, were there some times when Michael Cohen instructed you to ask questions of Rudy Giuliani? Correct. What type of questions? He wanted to know how the investigation of Michael Cohen began. He wanted to know whether it was a referral from Washington. How did it get to the Southern District of New York, which is the federal court right down the street here? And he wanted me to ask Giuliani if Giuliani knew. So Cohen was trying to get information from Rudy Giuliani? That's correct. Now, if we could take a look at Defense Exhibits B1006. Thank you. So this is an email that you sent to Michael Cohen on April 23rd of 2018. Do you see that there? Yes, it was. I do see it. And do you see the subject line, assignment? Yes. Were you reporting back on an assignment from Michael Cohen? Yes, what he asked me to do, right. And the email begins, I spoke with the person you asked me to. Do you see that? Correct. Who were you referring to? Rudy Giuliani. And then it continues. He said that he would find out exactly how the matter ended up in SDNY, and in particular, who in Main Justice approved this. Do you see that? I do. And is this something that Rudy Giuliani said to you in response to Michael Cohen's question? It is. I would like you to take a look at the second paragraph of that email. Do you see where it says the question, timing is premature? Yeah, I see it. What did you mean by that? Objection. Sustained. Jeez. Was that a response to something Michael Cohen had instructed you to do? Objection. Sustained. Yes, strike it. Counsel, let's take a minute. Can the jury please step out? All rise. Mr. Costello, you remain seated, please. Remain seated. You may be seated. Mr. Costello, I would like to discuss proper decorum in my courtroom, but I'm sorry, go ahead. I want to discuss proper decorum in my courtroom, right? Okay, so there is a witness on the stand. If you don't like my ruling, you don't say geez, okay? And then you don't say strike it, because I'm the only one that can strike testimony in the courtroom. Do you understand that? I understand. Okay. And then if you don't like my ruling, you don't give me side eye and you don't roll your eyes. Do you understand that? Do you understand that? I understand that. I understand what you're saying. Okay, thank you. Let's get the jury back. Are you staring me down right now? No, I'm just wondering how. Clear the courtroom, please. Clear the courtroom. Do you want me to answer your question? Sir, please. Step outside, please. Step outside. Step to the side, please. Step out, please. Quiet, please. Step out, please. Your Honor, may I object on behalf of the press? Your Honor, our lawyer is objecting to the press. Lawyer's objecting. We have a right to remain here. Step out. Step out. Why? This is an open courtroom. Step out. Any questions, any and all questions will be answered in the hallway. The press lawyer has a question. This is not an open forum. We will answer all questions in the hallway. Please step out. This is a Supreme Court courthouse. Step out. This is an open courtroom. It is open to the people, open to the public. You can't throw us out. Our lawyer has a question. This is a public forum. Why do we need to step out? Step out, please. Where do you want us to go? We have a lawyer here. I am the lawyer. Keep going, please. I will answer all questions out in the hallway. We will answer everything out in the hallway, but right now, everybody step out. We are guests. Why do we have to leave? Step out, everybody. Step out in the hallway. Let's go. Will this be on the record so that we can read it afterwards? Step out, please. Step out. Step out, please. Step out. The courtroom is cleared of people in the audience by the court officers at this time. Right? Okay, everyone. Courtroom was cleared, so now we're coming back. Here's the court. All right, let the record reflect that it's now 4:05. Let the record also reflect that the court officers had great difficulty clearing the courtroom because the courtroom is made up primarily of the press. And I can appreciate that the press wants to be present for every part of these proceedings. Therefore, this record is not sealed. The press will have access to this record. The fact that I had to clear the courtroom and that the court officers, including the captain, had great difficulty clearing the courtroom, and that there was argument back and forth between the press and including counsel for the press, goes to why I had to clear the courtroom in the first place. And that is, sir, your conduct is contemptuous right now. I'm putting you on notice that your conduct is contemptuous. If you try to stare me down one more time, I will remove you from the stand. I will strike his entire testimony. Do you understand me? Yes, Judge, I understand. Listen to the question and answer the question. Can I say something, please? No, this is not a conversation. Okay. All right, we can bring the press back in, please. Ready, Your Honor? Yes, please. Okay, the press is entering the courtroom. Same seat, folks. Same seats. Let's get the jury, please. Jury entering, all rise. You don't want me to rise? No. You may be seated. Case on trial continued. All jurors are present and properly seated. Mr. Bove. Thank you, Judge. And we will continue again, everyone. All right, so we're going to dive back in. And so it was the press that was making everything so completely out of control that the judge was absolutely frustrated here. All right, everyone, let's dive back in. Back to the direct. May I inquire? Yes. Mr. Burnick, if you could please bring up Defense 1008 in evidence and zoom in on the bottom of the email. Now, Mr. Costello, this is a message from you to Michael Cohen. Do you see that in the top left? Yes. And in the right, the date of May 16th of 2018, right? May 16th. You wrote at the bottom of this message, I will not pester you. If you want to talk, you know how to reach Jeff or myself. Do you see that? I do. Is Jeff Mr. Citron that you had mentioned earlier? That's correct. And what were you trying to convey here? Objection, Your Honor. I will allow it. You can answer. Yes? Yes. Michael Cohen had been complaining about the lawyers. I'm sorry, everybody. I need to take a drink. This interaction between the court and the witness, it just gets me every time. All right, just one moment. Michael Cohen had been complaining about the lawyers. He was complaining about Steve. Objection, Your Honor. Sustained. Move to strike. The answer is stricken. What did you mean by not pester you? Meaning he would not hear from me again unless he contacted me. So if we could bring this up on the left side of the screen and bring up the phone records. We could zoom into row 47. So we were just speaking about an email on May 16th of 2018, right? Correct. And the next call in the chart is Sunday of Memorial Day weekend, right? That's right. And who you called? Michael Cohen called me. And how long was the call? 1 hour and 36 minutes and 15 seconds. Did Michael Cohen give you instructions during that call without getting into what instructions were? Yes. And I understand there is a waiver. We're just trying to keep this narrow. So he gave you some kind of instructions and you discussed legal issues during this call? Yes, we did. Now, if we could take a look at the government's exhibit 206. And this is an email that you sent to Mr. Cohen on June 7th of 2018. Do you see that? I do. And from the text of the email, it looks like there's been some conversation between you and Mr. Cohen about Mr. Giuliani, correct? That's correct. Now, if we could zoom in, so does this part of the chart, Defense 1018, reflect a series of calls between you and Mr. Cohen on the same day in this email? Yes, it does. And do you see row 57 of the call that lasted 46 minutes and some change? I do, yes. Who initiated that call? Michael Cohen. And during those calls on June 7th, did Michael Cohen instruct you to contact Rudy Giuliani? Pause. You could take a look at the second paragraph of the email on the left. It says, after you called me back at 2:43 and we spoke, I called and left a message for Rudy? Yes. Does that refresh your recollection as to whether or not you got instructions that day about calling Mr. Cohen from Michael Cohen? Yes. Now, if we could make the phone chart defense here. By the way, there are two Mr. Cohens involved. There's a Michael Cohen and a Mr. Cohen, everyone. And does this part of the chart reflect a series of calls on June 12th and the last one on June 13th of 2018? That's correct. And I just want to zoom in on the last paragraph of this message. It's on the second page. Do you see where you wrote, please remember if you want or need to communicate something, please let me know and I will see that it gets done? Right. What were you communicating to Mr. Cohen there? Objection, overruled, you can answer. Mr. Cohen was making constant complaints about Rudy Giuliani and what he was saying to the press. And he was also complaining that his law firm, McDermott, Will, and Emery, objection, sustained, hadn't been paid, sustained. Again, please just answer the question. Okay. Now, if we could take a look at Government Exhibit 208, which is in evidence. This is a message that you sent to Michael Cohen the next day, June 14th, correct? Correct. And do you see where you wrote, I really want certain things to happen. You should make that known. If you really want other lawyers to refrain from saying this or that, you should make it known. Do you see that? I do. And just very, very narrowly, with respect to those two sentences, what were you communicating to Michael Cohen on June 14th of 2018? That was in response to his complaint. And I said, if you want to let anybody know what you are complaining about, just tell me and I will pass it on. And who were you telling Michael Cohen you could pass it on to? Rudy Giuliani. Mr. Costello, did you ever put any pressure on Michael Cohen to do anything? No. Did you ever pressure him to interact with Rudy Giuliani in a certain way? Not at all. Did Mr. Giuliani ever put pressure on you to try to exact information from Michael Cohen? Objection, sustained. Did you ever perceive any type of pressure from Rudy? Objection, sustained. Move to strike? No. Move to strike, Your Honor. It's stricken. During your interaction with Michael Cohen, did you consider him to be a client? Absolutely. I had to treat him that way. And whose interest did you have in mind during the course of that relationship? Exclusively Michael Cohen's. Did you care about President Trump's interest while you were dealing with Michael Cohen? No, my obligation was to Michael Cohen. And at some point, did your firm seek payment from Michael Cohen? Yes, they did. And did he pay? No, he did not. Were you aware that the firm was trying to collect on that? I'm sorry, I couldn't hear you. Were you aware of the efforts by your firm to try to collect payments? No, they didn't sue. The amount wasn't enough. Now, before I sit down, we've met before, right? Yes. And you've also had meetings with state and federal prosecutors regarding Michael Cohen, right? Oh, yeah. Did you turn over documents during those meetings? I did. A lot of documents. And answered questions from both state and federal prosecutors at different times? Yes. And more recently, have you appeared in the media in conversations about this case? Yes. Fair to say frequently? Yeah. And have you also testified in Congress about this case? I did, the House Judiciary Committee. And that was actually while this trial was ongoing, right? I think it was last Wednesday. Nothing further, Judge. Your witness. Thank you, Your Honor. And now we are at cross-examination, everyone. All right, so we finished our direct. And this cross is quite good. So let's dive into that. So just as a friendly reminder of the way that the rules of evidence work, any evidence that he used during his direct can be used on cross-examination. Now, she could not have gotten any of that evidence in, any new evidence in. She had to have the door open through the direct examination. So we'll see what she does here. Good afternoon, Mr. Costello. Hi. On April 17th of 2018, your partner Joel Citron reached out to Michael Cohen by email. Is that correct? Jeff Citron. I apologize. Jeff Citron? Yes. To see if he would be interested in meeting with you, is that correct? I'm sorry, say that again. To see if Michael Cohen would be interested in meeting with you, is that correct? No, the email speaks for itself. Well, let's take a look at People's Exhibit 512P. Well, before we put it up, Mr. Citron did not email Mr. Cohen to see if he wanted to meet with you. He did. Yes, he did. And didn't Mr. Citron in that email lay out all of your qualifications, that you're a former chief of the criminal division of the U.S. Attorney's Office, and that you had represented famous people like Leona Hemsley and George Steinberg? Didn't he send that type of email to Mr. Cohen? I don't remember. The email speaks for itself. Well, let's take a look at that. Let's take a look at People's Exhibit 512P. Do you recognize that email, sir? Yes, I do. Who is that an email from and to, and who's it copied on? Who's copied on that? That was from Jeffrey Citron to, it's blocked out, but this should have been Jeffrey Citron to Michael Cohen. And you're copied on that email, sir? I'm sorry? Are you also copied on that email? Witness reading. I know there are certain redactions, but does it appear, what's confusing to see is that this is saying it's from Michael Cohen to Jeffrey Citron, but I guess this is a string. It's a string. So look at the bottom. So I'm having trouble seeing the string. Yes. So you were on those emails? Yes, I was. I offer those into evidence. No objection, accepted into evidence. So now you see an email that Mr. Citron sent and copied you on. Are you aware of that now? Do you see the emails exchange, extolling your experience, your famous clients, and what you wanted? Except you misstated it before. You stated I was chief of the criminal division. It's deputy chief. I apologize for that. Deputy chief of the criminal division. Is that otherwise accurate, the question I asked you? It is, yeah. And you were hoping that Michael Cohen would hire you as his lawyer, correct? I wasn't hoping anything. It wasn't my email. I'm sorry. Had you heard about the case in the news, sir, that Michael Cohen had a search warrant in early April of 2018 and the personal attorney of President Trump? Had you heard about it in the news? I probably did, yeah. It was big news, right? If I heard about it, I guess it was. And you and your partner thought this would be a good opportunity to see if you could get Michael Cohen as your client. Isn't that correct? No, this was Jeffrey Citron's relationship with Michael Cohen. He knew him for 10 years. I didn't know Michael Cohen from a hole in the wall. So you weren't interested in having him as your client? No, I wasn't. And so you met with him, but you weren't interested in retaining him? Is that right? I met with him because Jeff Citron made an arrangement with Michael Cohen, and he asked me to come along because Jeff Citron is a real estate attorney, and this was obviously a criminal matter. So you were just accompanying him to this meeting? Well, I wouldn't say I was just accompanying him. It was Jeff Citron's client, not mine. But I thought you said they knew each other. He wasn't his client? I thought you said they knew each other. Yes, Jeff Citron knew Michael Cohen for at least 10 years. So you knew at the time, based on the news, that Michael Cohen was President Trump's personal attorney, correct? I think I knew that before we entered the Regency Hotel, yes. And if you could land him as a client, personal attorney to the president, that would be a big case for your firm, wouldn't it? I suppose so. And it would get you public exposure, wouldn't it? Yes, it would. And you would be in the news as his attorney, right? I guess that's true, yes. And this is what you would call a high-profile case for you, right? Probably, yes. And it would connect you with the President of the United States, right? Because he was his personal attorney, right? No, it would not. It wouldn't connect you with the President of the United States and those who were close to him, like Rudy Giuliani. No, Rudy Giuliani wasn't involved in representing President Trump at that point in time. He wasn't in the picture at all. But just a few days later, he was representing President Trump, right? 2 days later is not the date that we met, yes. So is it your testimony that this wouldn't push you into an arena with Rudy Giuliani and President Trump by representing Michael Cohen? I don't understand the question. What do you mean it would push me into the arena? Well, I will withdraw the question. Having Michael Cohen as a client, you said would be a big win for you and your firm, correct? I didn't say that, you did. I'm asking you, would it be a big win for you and your firm? No, I would say no. I didn't want him as a client with the firm. Would it be something that you would announce on your website, your firm's website, if you had on him on the client list as your client? I don't know what the firm would do. Okay, can we please show people's 528M? And maybe you can review that email and let us know who it's from and who it's to. Yes, I've read it. I know what it is. Who is it from and who is it to? This was from me to my son. What is the date on the email, sir? April 20th. I offer that into evidence. No objection. Accepted into evidence. Can we put that up on the screen, please? And I would like to ask you to please read it. Please read your email to your son and your son's response, if you would. You want me to read it? Yes, sir, if you're able to. Okay, from the bottom up, it says, I will be on the team. That was Michael Cohen's phraseology. Quote, it would be an honor to have you as part of my team. I will be eternally grateful for the help and the guidance that you have already given me. That's a quote from Michael Cohen. If you would just read the email, please, from your son. That's what it says. It says, it's in quotes. It says, Michael Cohen, personal attorney to Donald J. Trump. I did read it. Okay. The second paragraph, this is not public. Oops, sorry, everybody. This is not public. That too was from Michael Cohen, yet. So do not say anything to anyone about this. I do not know when we will make an announcement, but I have been authorized to contact Rudy Giuliani as counsel to the President Trump and tell him I will be representing Michael Cohen. That's my Michael Cohen's instructions, right? So what you're saying is you were not saying that you were going to be put in your firm's, you were not going to put it in your firm's website and you were not going to announce it. Is that right? This has nothing to do with my firm's website. It says, I don't know when it's going to be announced. Please keep it to yourself. Announced by Michael Cohen. So what you're saying is that that's all Michael Cohen's language, not you telling your son that? Okay, yes. Okay, can you read your son's response? Wow, that's big news. Congrats, Dad. I hope this leads to a lot of good things coming your way. That's from my son, yeah. And so you were telling your son that you were going to be involved in this big case and it was going to be a great big news for you and your firm, is that right? No, I was telling my son exactly what I told my son in this email, and this is his response to it. Okay, now let's talk a little bit about meeting at the Regency on April 16th of 2016. Now, Mr. Cohen agreed to meet with you and Mr. Citron, correct? Yes, on April 17th. Mr. Cohen requested to meet with us. He asked us to come to the Regency Hotel. Sure. After your partner, as we saw in the email, reached out to him and asked if he would like to meet with you, isn't that right? No, that's not what he said. He said to Michael Cohen, I have a partner who used to be the deputy chief of the criminal division of the U.S. Attorney's Office. If you want to pick his brain, let me know. And Michael Cohen responded immediately, yes, I want to meet him. So Mr. Citron reached out to see if Michael Cohen would want to speak to you and you had a meeting with him, is that right? Yes, that's what's in the email. That's what the email said. Okay, so let's talk about that meeting on April 17th. Sure. Now, you said you met with him at the Regency Hotel where he was staying with his family, correct? We met with him at the Regency Hotel. I didn't know where he was staying when I met with him. And you knew based on the news of the search warrants that Mr. Cohen had been through a traumatic event, right? Yeah, I would say sure. And because 8 days earlier, the FBI had raided his apartment, his hotel room, and his office, right? I wouldn't use the term raided. They executed a search warrant. And you know from your experience that executing search warrants is that they come into your place, wherever it is, and they take your personal items, phones, your devices, documents, etc. You know what a search warrant is, do you not? Of course I do. And you knew as a result of that, you knew obviously he was under criminal investigation by the Southern District of New York, right? I did, yes. And that's pretty serious, isn't it? Generally, yes. And in fact, having a search warrant executed at a lawyer's office and hotel rooms, etc., that's pretty big. Pretty serious, isn't it? It's very serious and it requires special proof. And in fact, you said that, well withdrawn. Mr. Cohen was visibly shaken up that day, wasn't he? He was suicidal that day and acting manic, and he was manic. And you said he was pacing back and forth, right? That's correct. And you, oh, puzzle piece, everyone, pause. One moment, please. Oops, uh-oh. Hold on, one moment. Okay, I verified that we are doing a live, and let's going back in. Here we go. And you said he was pacing back and forth, right? That's correct. And you had been a criminal defense attorney for how long, sir, at that time? Oh, 40, 50 years. Now, and in all that time as a criminal defense attorney, you can understand how traumatic it is for somebody to go through that kind of experience. Talk in the microphone, please. Oh, I'm sorry. As a criminal defense attorney for all of those years, you can understand how traumatic it is for someone to go through that kind of experience, right? Yes, sure. And as a criminal defense attorney, you can empathize with someone who's gone through that experience, can you not, sir? Yes. But you thought he was being a drama queen, didn't you? No, I didn't know Michael Cohen. I've never met him before in my life. He was putting on quite a show, and I didn't know when he initially said, Sir, I'm answering your question. The witness needs to be allowed to finish his answer? Surely he can finish his answer. He was putting on quite a show. And he explained to us, he told us that 2 nights before, he was on the roof of the Regency hotels and he was going to jump off and unalive himself because he couldn't handle the pressure of what he saw as an ongoing criminal case coming his way. Sure. And you remember testifying in the grand jury in this case, sir? Yes, I do. And you remember that was in March or March 20th of 2023? Approximately, yeah. And did you tell the grand jury that you didn't know whether he was being a drama queen or not? Yeah, and that's because, well, I'm asking for the witness to answer the question, Your Honor. Sir, if you're able to answer the question, yes or no, please answer yes or no. If you're not able to, just let Miss Hoffinger know and she will rephrase it. Do you want me to answer the question, yes or no? Sure. Did you tell the grand jury that he was acting like a drama queen? No. I said I didn't know whether he was acting like a drama queen, right? Well, you don't like drama queens, right? I just didn't know because I didn't know the guy. I couldn't assess whether these actions by him were genuine or not, but my partner thought they were, and he knew him for 10 years. So Michael Cohen ultimately chose a different lawyer to represent him, right? Not you, is that correct? Well, he had one lawyer at the time that was talking to him. That was that McDermott, Will, and Emery. And he was also talking to Guy Petrillo, who he later on in June, whatever the date was, he announced publicly that he was going to retain Guy Petrillo. So he retained Guy Petrillo instead of you. Is that correct? Retained? You mean he signed a retainer agreement? I don't know. Whether he signed a retainer agreement or not, he ended up going with Guy Petrillo to represent him in connection with this matter in the Southern District, not you, correct? Yes, that's correct. Counsel, please approach. Sure. So I haven't asked the jurors if they can work late. Yes? How much more do you have? I probably have maybe half an hour at the most, but let's come back tomorrow. Okay, thank you. End of sidebar. Jurors, we're going to stop at this time. Before I excuse you, I remind you, please, not to talk either amongst yourself or with others about anything related to this case. Please continue to keep an open mind. Do not form or express an opinion about the defendant's guilt or innocence until all of the evidence is in, and I have given you my final instructions on the law, and I have directed you to begin your deliberations. So that is the point at which the cross-examination was halted, everyone. Oh, my goodness. All right. So, oh, goodness gracious. All right. So at that point, I would have to say, again, that this cross-examination was absolutely amazing. She did a fantastic job on her cross-examination. So with that, I have one more very interesting piece that they did discuss before they actually left for the day. I think these jurors could keep this. I know, it'd be difficult. Don't like him. I know. She is an awesome attorney. I agree. So we do have a few more pages of a little discussion that they will have after the jury has left. So we've got to go into that. All right, so all rise, remain seated. Sir, you may step down to the witness. Your Honor, before Mr. Costello goes, would you please ask him or tell him that he's not to be in contact with the defense team directly or through other parties while he's still on the stand? As counsel, we are going to and do abide by that either way. I generally do not give that instruction, but you can ask him tomorrow whether he has or has not. Witness is excused. Miss Hoffinger, do you think you have about half an hour left? I'm not going to rush you. Understood. Probably half an hour to 45 minutes at the most, and I may cut some of it tonight. So, okay, and then I expected you will have some redirect? Yes, Your Honor. But I don't expect that it's going to be long. Okay, then at this point, do you expect to call any other witnesses? Not at this point, Judge. We are going to do some thinking tonight, but obviously there are some limitations on that, but not at this point. That can change, but it appears that tomorrow, very early in the morning, you will rest, and I will excuse the jury at that time. All right, thank you, everyone. Judge. Your Honor, we don't have to do this now, but at the conclusion of the People's case at sidebar, we said that we are going to move for a trial order of dismissal. I do not have to do that now. We can do it now. That's fine. Thank you, Your Honor. This is Mr. Blanche, everyone. All right, it's Mr. Blanche. Your Honor, for several reasons, we believe that the court should enter a trial order of dismissal now. First, there's absolutely no evidence that the filings were false. I pause for a moment, everyone, because this will give you a glimpse into what the closing statement's going to be by defense, all right? So we'll have a little glimpse, all right? So we'll have a little window into what the closing arguments are going to be on Tuesday, all right? The business records were not false. There's no dispute that Mr. Cohen provided legal services to President Trump in 2017. Not only did Mr. Cohen admit that, but Ms. Tarasoff, when she booked the records that are part of at least 12 of the counts, said the same thing. When they were entered in the Trump system, they were entered as legal expenses for a retainer agreement. There's no dispute that in 2017, that's exactly what Mr. Cohen was doing for President Trump. Now, not only that, but when the invoices were sent to the Trump Organization, there's no evidence that they were mishandled or entered falsely. So when the invoices are sent, President Trump is not in New York, he's in the White House, and the invoices come in for services rendered. And Mr. Cohen testified that he's rendering services for President Trump during that time as his personal attorney. So at the start, there's absolutely no false business filing. There are accurate business filings. Second, there's no evidence that there is any intent to defraud by President Trump in connection with these filings. So even if there was evidence that these records themselves were false, but they weren't, these are records that were generated in connection with Michael Cohen's personal relationship and personal attorney-client relationship with President Trump in 2017. He was paid first by the trust for 3 of the months, and then out of personal funds, the personal bank account for President Trump. Well, President Trump was the only person that had any signatory authority over that bank account. So again, the idea that there would be any sort of intent to defraud by President Trump when the invoices are going to the Trump Organization, a check is being generated for him to sign in the White House, for the president to sign in the White House, and then which he signs in the White House, there's no evidence that there is any idea of any intent by President Trump at that time to mislead or to hide or to falsify the business records. And again, now, these are records of his personal records of the Trump Organization. So again, if there was any intent to defraud, there would be evidence of something besides what we have here. Either the records are entered into a different manner, either they are entered in a false manner describing something, services that are different from what's actually rendered, or something to give even a little bit of evidence that there is an intent to defraud. We have none of that. And third, Your Honor, the other crimes that purportedly are being covered up in connection with these false business filings, there are no other crimes. And now the people rested earlier today. And there's no evidence, zero evidence, that anyone was thinking about campaign finance charge in 2016 when this payment was made to Ms. Daniels. There's also no evidence that anybody was thinking about the campaign finance charge when Mr. Wesselberg and Mr. Cohen met in January of 2017 to come up with a way that he would be paid. There is a $35,000 monthly retainer. It was established months after the election. And so there's simply no evidence that there is any effort to conceal anything not only by President Trump, but also by any of the others involved. And so the prosecutors have talked in their opening statement and in papers about some sort of conspiracy to influence the election. But as the court knows, there has to be something illegal about this effort. There has to be something illegal about the efforts by the co-conspirators to influence the election. And what the evidence shows is that they all got together in 2015 and agreed that they would talk about positive and negative stories, and that they would be positive and negative stories pushed and positive stories pushed and negative stories pushed. And that Mr. Pecker would keep an eye out for anything that he heard that was bad about President Trump. Now, there's no evidence from any of the witnesses who testified of any criminal intent with respect to any of those of any kind. The underlying criminal intent that the people are suggesting, FICA, New York State tax fraud, some other business record fraud that they claim showed some sort of criminal intent, as a matter of law, they should not be allowed to use any of those predicates when at the end of the day, there's absolutely no evidence that Mr. Pecker, Mr. Cohen, President Trump, Dylan Howard, or any of the other purported co-conspirators for this misdemeanor state law crime had any criminal intent at the time that they were engaging in this conduct. By the way, there was no discussion at this October 2015 meeting about a catch and kill. Nobody said that. There was no discussion about any financial payments that would potentially be made with respect to any stories. So you don't have any evidence of any criminal intent or criminal conduct at this supposed first meeting where the conspiracy is born and then played out over the next year plus. Then, when you look at actually how the conspiracy played out, Karen McDougal, if the evidence is to be credited, she never even wanted her story out. She was looking to start a career anew, jumpstart her career. She wanted an arrangement with AMI so that she could be on the covers of magazines, write a column, not catch and kill a story. Well, that's the words used by Mr. Cohen, and in opening statements, that's not the evidence that came out at trial. That was a demonstrably false story, everybody agrees. So again, if there's some conspiracy to influence an election, how on earth is keeping a false story from the voters criminal? So it's a false story, and there's a decision made to pay off the person who's spreading the false story. That means that a false story is not being presented to the folks that are voting in New York State. That's not a catch and kill, Your Honor. Certainly not a criminal catch and unalive. I think I've hit my max on saying the K word, everyone. As it relates to Ms. Daniels, AMI wanted nothing to do with that. There's lots of testimony about that. When it came to catching and unaliving, which is supposedly the conspiracy that's going to be entered in between Mr. Pecker, Mr. Howard, Mr. Cohen, Mr. Trump, if that was really a conspiracy, AMI jumped out of the conspiracy. As you've heard over the past several weeks, Mr. Pecker was insistent that he wanted nothing to do with any kind of catching unalive with Ms. Daniels. In fact, that led to Mr. Cohen entering into an NDA with her. Mr. Cohen is not a member of the press. He doesn't own the National Enquirer. This isn't a catch and unalive story, which is supposedly the conspiracy that was formed in October of 2016. So these three separate incidents by the jury that this jury have heard about that gave conspiratorial criminal intent to the participants are not that at all. So the underlying predicate that gives rise, that makes this misdemeanor a felony, there's simply no evidence of any intent or criminal intent of any kind of any of the parties in 2016, 2017, or for that reason, the court should enter a verdict in favor of the defendant. Finally, we've been saying this for months, and we've heard Mr. Cohen testify the past several days. There is no way that this court should let this case go to the jury relying on Mr. Cohen's testimony. And I don't think the people will disagree that without Mr. Cohen, there is no case. Meaning, without his testimony last week and today, there is no case. And he not only lied repeatedly in the past under oath, but he lied in this courtroom. And I'm sure that the people will say, well, he didn't really lie, or he misremembered. But we put on irrefutable proof when he testified on direct about his phone call, and he remembers specifically a key part of this crime that took place, a key part of keeping President Trump updated. And he said it 19 times on his direct. And today, he said he talked to him about it more than 20 times. That's obviously a key part of their story. He confidently said, and this gets really good, everybody. He confidently said that on October 24th, when he had that call just after 8 o'clock at night, the purpose of the call was to call Keith Schiller, have Mr. Schiller give the phone to President Trump, and then, so you're asking me to find Mr. Cohen not credible as a matter of law? Yes, absolutely. Because it wasn't just that lie, Your Honor. He also lied to this court repeatedly, for example, about his testimony in front of Congress and whether he said that he never asked for a pardon. It shouldn't move the court that he continues to lie about that. I mean, the court has the transcript. The court has the evidence. The testimony that he put in front of Congress where he says something that we know from the testimony at this trial was not true, and he still doubles down. So you want me to take it out of the jury's hands and decide before it even gets to the jury that as a matter of law, this person is so not worthy of belief that it shouldn't be considered by the jury? That's what you're asking? That his entire testimony should not be considered by the jury? Absolutely. That's exactly what we're asking the court to do. Again, he didn't just catch him in a lie, Your Honor. We came in here with a history of lying under oath. Again, as Your Honor ruled before this trial started with respect to that issue, Your Honor said correctly that he hadn't appeared in front of you so that it wouldn't be appropriate, just based on past allegations of lying under oath. It wouldn't be appropriate to say that he can't testify. He testified and he lied under oath in this courtroom. And the consequences of that lie, if accepted by the jury, is a conviction, potentially. And so imagine that you said his lies were irrefutable, that you think he's going to fool 12 New Yorkers into believing this lie? Well, Judge, it's an irrefutable lie. I certainly hope he doesn't convince 12 jurors. I would like to hear from the people. The standard, as the court knows, for the motion the defense just made requires assessing the evidence in the light most favorable to the prosecution, assuming that the jury credits the people's witnesses and giving the prosecution's evidence the full weight it might reasonably be accorded. So, against that backdrop, there's just no argument that the evidence falls short of the standard the people need to show to defeat this motion. Let me address, I think Mr. Blanche made 3 key arguments. First is that there's no evidence of falsity because Mr. Cohen performed or provided legal services in 2017. The trial record overwhelmingly rebuts the argument. There's no evidence of falsity. Among other things, Mr. Cohen performed similar legal services in 2018 and was not paid. Then, of course, you have the People's Exhibits 35 and 36, accompanied by the testimony of Jeff McConney explaining those documents, which memorialize and track the conversation of the $130,000 wire transfer to Keith Davidson into the exact $420,000 reimbursement that Mr. Cohen ultimately received. On top of that, you have the admission in at least 3 other pieces of evidence we introduced. People's 81, in which the defendant signed and certified Office of Government Ethics form, which explains that the footnote we pointed to on page 45, that the defendants reimbursed Mr. Cohen for expenses he incurred. We've got People's 407G, I believe it was, which was the public statement from the defendant admitting he reimbursed Mr. Cohen. You have the testimony from Miss Daniels' transcript 2903, where she acknowledged from civil litigation in California the defendant acknowledged Mr. Cohen had to be reimbursed. The evidence this payment was for reimbursement and not for retainer of legal services performed is overwhelming. And at minimum, a rational juror can conclude beyond a reasonable doubt the invoices, the ledger entries, and the signed checks with check stubs all contain false instruments. Mr. Blanche made a couple of arguments regarding intent to defraud. At least one of them touched on the first element in the CGI instruction, whether the defendant made or caused a false entry in a business of his entries. Because Mr. Blanche talked about the accounting staff and the normal operations of the accounting staff. As a matter of law, Your Honor, it's sufficient more than sufficient if the defendant set in motion the sequence of events that led to the false entries being made, and if those false entries were the reasonable, foreseeable consequences of his actions. So I think there can be no question related to the overwhelming evidence leading up to the payment scheme that the defendant caused the false entries. On intent to defraud, again, Your Honor, you already held in denying the defendant's omnibus motion that as a matter of law, the grand jury supported, at that point at least, 3 different theories of intent to defraud. The first was evidence of general intent to deceive, and here the evidence in the trial record, including the overwhelming record of concealment, supports general intent to deceive. The court also acknowledged general intent to deceive the voting public supports, also supports the element of intent to defraud. Then, of course, as Your Honor also held on page 19 of your omnibus decision, that the evidence supports a showing of intent to deceive government regulators. On this last element that Mr. Blanche discussed, the intent to commit, aid, or conceal the commission of another crime, Your Honor, there were weeks and weeks of testimony from witnesses who testified and whose testimony was corroborated by emails, bank records, contemporaneous phone calls, text messages, and other documents of a conspiracy that was entered into in Trump Tower in August of 2015 that was then effectuated through unlawful means. The unlawful means include an illegal corporate contribution to Karen McDougal, the excessive individual campaign contribution to Stormy Daniels. And then, of course, Your Honor, there's extensive evidence of other false business records being created in the course of carrying out the conspiracy, including the false invoice from Investor Advisory Services to conceal the intended transaction between AMI and Mr. Trump, as well as all of the false documents that Mr. Cohen submitted to his bank in order to open both of the shell companies he intended to use to tender the transfer. There's a lot more. We don't need to give a full summation in order to rebut the information Mr. Blanche gave. The trial evidence overwhelmingly supports each of the elements of the offense, and the trial order of dismissal is not warranted. I'll reserve decision. Briefly, Your Honor, the evidence of there being any sort of illegality in this conspiracy, a conspiracy isn't a conspiracy just because 3 people get together and talk. There has to be an illegal objective. False filings of the AMI records doesn't qualify. False records years after the fact, and the fact that there was a campaign contribution that Mr. Cohen ultimately pled guilty to, that shouldn't qualify. The evidence that came into this courtroom is really what the court should consider. You have no evidence of a catching on alive at that meeting, just evidence of what reporters and politicians do every day during the campaign, and the people have turned that into the beginning of a conspiratorial agreement and relationship. But that's not what the evidence showed over the last several years. At the end of the day, then I'll sit down. You have a book records violation where you have legal expense. That's the entry, that's false supposedly. And you have testimony, non-contrary, that Mr. Cohen was President Trump's lawyer in 2017. So it's hard to imagine what book, how this was supposed to be booked by by Miss Tarasoff when she gets the invoice. How is she supposed to book the fact that the lawyer working for President Trump was his personal attorney and had a legal expense? So I was going to just finish with Mr. Cohen. I won't go on and on. The other, in addition to what I've already said, Judge, is the exacting testimony that he gave this jury, and we crossed him on it. But a lot of the objections were sustained. The exacting testimony that he gave about particular conversations that he remembered with President Trump in 2016, we never saw those. They're not in any of the notes with the special counsel, with the Southern District, or with the Manhattan District Attorney. That's something that we talked about before. He definitely talked about it in the grand jury and in the meetings that there were phone calls and that there were conversations. That's a lot different than what he said on the stand, and he gave very specific recollection. That's not something that we knew about. Apparently, the people knew he was going to do that. Under the law, if he's going to change his story like that, they should provide us with notes of that. They didn't. That's another reason why his testimony should be rejected, Your Honor. Your Honor, as this court knows, as any defense counsel knows, they have received probably hundreds of pages of notes of conversations with Mr. Cohen. It is simply not the case. His testimony at this trial was not reflected in the notes. The defense counsel had ample opportunity to impeach by omission. Where impeaching by omission was permitted, the court permitted it. Where it was not appropriate, the court did not allow it. There's no evidence, none, that his testimony in this courtroom was new. One other correction. The false entries on the invoices, general ledger entries, and the checks or check stubs were these payments that were falsely described as payments pursuant to a retainer for services rendered in a given month, not the legal expense standard. Thank you both. As I said, I'm going to reserve decision. See you tomorrow at 9:30. Can we approach? I just have a scheduling question. And then that's where we will stop the reading for tonight, everyone. My goodness gracious. So that concludes Mr. Costello's testimony and then the fight for a motion to dismiss at the very end of that. He's another one of the defense counsels. He's part of the the state's team. Yes, I'm getting anxious. Oh, I thought they did a great job of setting it all out. I thought they did a great job. No, I would say, again, I think the prosecution, I can't think of anything more that they could have done. It truly is in the hands of the jury. So did they prove Cohen lied on the stand? Well, the jury will tell us. It's up to the jury. Okay, yes, you're very welcome. You're very welcome. Yeah, so we had, I think, 4 or 5 different attorneys on the prosecution team, and we saw mostly 2 of them doing most of the questioning, but the one who was giving the information about the law, it was kind of more of their academic person. Do you think he lied? Do I think he lied? Oh my gosh. Honestly, it would be very difficult for me, and again, to be completely honest, for me to make a determination if someone lied without actually looking at them. That's how I assess if someone is telling the truth or not. Based off of words on the paper, I don't think I can make an accurate assessment. So much yes, it really is a process, Stephanie. So is Trump guilty? Well, that we don't know yet. Again, we've got to wait for our jury to tell us. They are our fact finder. We've got one side saying, these are the facts, and he did it. We've got the other side saying, these are the facts, and he did not do it. So we have to have our jury determine which one's true. Testimony from other support. Yes, VC. And that's how this case was put together, very strategically, because everything was put into place in order to kind of build up Michael Cohen's testimony. So they set out all of the different pieces before Cohen went in to testify. Who goes first in closing? Great question. So I believe in New York, the defense goes first and then the state goes. Where I come from, the state would go first and then defense, and then the state goes again. Oh, wait, hold on. It's getting late, everybody. Let me think again. Yeah, the defense goes first and then the state. And the state has to finish. The state goes last because the state bears the burden. Judge felt he lied. Could he dismiss all the Cohen's testimony? I suppose it's possible, but again, the credibility of the testimony, that's something that's determined by the jury. That's not a question of law. That's a question of fact. The judge is there to determine questions of law. So, yeah. To say without seeing it, we have accessible it's hard to tell. I really, again, I am completely open either way. I'm open to Cohen completely not being truthful and to also being truthful. I could go either way on this when it comes to this particular matter. I just don't know. I have not spent enough time making that assessment at this point, but yeah. That's a lot. We've got a lot of that corroborating evidence. So even if Cohen isn't completely being truthful, is he being truthful enough for the jury to believe enough of it? I think the jury is going to ask to look at some more evidence. Could very well be. Could very well be. And they can. They can request exhibits. They can request various information as well. Yes, and I mean, again, because they ultimately, their job is to find the facts. So they are the ones that will tell us. They will be the ones. I thought it was great how the judge was like, "Are you telling me that 12 New Yorkers?" I was like, "You tell them, Judge." That's right. I mean, come on, come on. Still have a bunch of other cases. Oh my gosh, Kristen. Oh, we do. We really do. We have so many more cases, everybody. Oh my goodness gracious. So these will probably be the last of the transcripts for the testimony that I will be reading. I do plan to put together something regarding the jury instructions. I may do some of the summations, but I probably won't read through the full summations just because we've gotten so many motions to dismiss as we've gone through this. Florida question, yes, yes. When Cannon was confirmed, was it known where she would be assigned? That I don't know, Mary. That's a great question, and I do not know. I do not know exactly how that process works. Was patient with the witness? Yes, I think so. Are you finishing this up? Yes, I'm kind of doing the Q&A portion for tonight. But what I'm going forward to say here is that we're moving in Florida. We're going to be moving to the Florida situation very soon. We still have summations, and then of course we've got those jury instructions, and I do want to go through that and kind of talk about that. But what's really going on right now is we need to keep an eye on Florida. So we're keeping an eye on Florida, and the next one too, everyone. We have the Hunter Biden trial coming up as well. Menendez is in the middle of his trial right now, so he still has ongoing information that's being done. And then Biden, again, in just a couple of weeks. Was Costello a reputable witness? No, he was not. No, when you've got that kind of an attitude, immediately it's very difficult when you are immediately disliked. So you just have to, it's one thing to be assertive and be confident. It's another thing to be like a real jerk. And if, you don't want to play that game and come out as the jerk. Yes, so Biden has that felony charge, weapons charge. And there's a lot of really interesting things actually going on. They just had the pretrial conference last week. And then they're kind of fighting back and forth over this term of what the term addict means and what role that's going to play. So there's actually a lot of levels involved in that. I mean, just from a purely legal academic point of view, it's a very interesting set of facts here in that. Any thoughts on Cannon? So at this point, and again, I'm putting together, I will be doing a live. I will be moving into Florida very soon, everyone. I'm putting together a set to kind of go through the information that's been unsealed with as far as Cannon goes, and also break down again. I know a lot of people have been, oh my gosh, it's indefinite, and we've got problems with that. But as I've shown you before, she set out that request, and Jack had requested it to be moved to July, and then the speedy trial situation to be moved to July, and then Trump and the other defendants, one had said August, the other had said September. So she actually had split the three and has pushed that speedy trial date to August. So she, for me, when I'm just crunching the numbers, it's not looking like it's so extreme. What I think is happening here is that she is just taking up so much time and getting so far into the weeds where I don't know that she's really putting her attention where it needs to be in order to kind of get this case rolling. And I think she's doing that because she doesn't have any experience. That's where I'm at with her. Now, Jack just put in that request for a gag order in Florida. This is going to be the point at which things are going to turn, because we had a gag order in New York. We had 2 gag orders in New York. We had a gag order in DC. And so now if we're going into Florida and he's making this gag order request and she dismisses it out of hand, now we're on the appeal train. So I would definitely say that we've got some work to do. And we're definitely needing to take some action to kind of close up those extrajudicial statements in Florida. Yeah, she's hemmed in good. That's a great way to put it, VC. I think that's accurate. I think that's accurate. And again, I think if you think my perspective on it, everyone, and of course I could be wrong. This is just my view on it, is that, when you're so scared and you're so uncertain of the terrain, you go very slow and very carefully. And so it takes you 5 years to go the same amount of distance that someone with training would have gone in 6 months. That's what's happening. But for her, at this point now, she had to have something to kind of box her in, to force her to like pick up the pace a little bit. And so I think that's really what's going on. Yeah, I mean, she needs to pick up the pace, but she's scared, and I understand why. And I'm not trying to say that that that's appropriate or that it's not appropriate. I'm just saying it is what it is. And for her to just be so carefully just stepping an inch at a time through these motions and through all of these hearings, like I'm not in her shoes, so I can't accurately say, well, that's crazy. But looking at it from a legal perspective, it's a classic thing that happens to a lot of our baby judges, is that they are so worried about screwing up or don't know what they're doing, that they just are going so slow and methodically that it's not getting done. And so it's like kind of backfiring. This super careful, slow, slow and steady is backfiring because she's not getting stuff done in the time that she needs to get it done. So she may not be familiar with that. I think she thought, wow, I can really run with this, or I can go as slow as possible and make sure every single thing is as done as perfectly as possible. But perfection isn't not what we're achieving in the legal system. We're just trying to do our best. So that's my take on canon. That's just my view. Yep, that's my view on it. Shall case has got the level of care that these do. Well, and the thing is, Easton, that's a great point. But to be perfectly honest with you, I don't think our cases get this much publicity. But our defense counsel and our prosecutors, they bust their keisters on these cases. Like, these, if you're going to trial, you don't go to trial every day. You only go to trial on those top, 5% of your cases. And when you go to trial, this is exactly the amount of effort that we give to every trial. This is it. You just put everything into it. And then when you're done, you go home. If you're lucky, you go to sleep for the night, you get up, and then you start again tomorrow. So, I mean, we definitely try, but this kind of publicity is certainly is nothing like any of our other cases. She's outside pressure from something. Well, Susan, there's really no way to truly know unless she tells us, I mean, we can guess, but, we just don't, there's just no evidence of it. It could very well be. It could be. I'm not saying there's not a possibility, but it's not even methodical. It's very confused. Well, right. It seems that way. It's because it's just not precise. It's just slow. It's like if I go super slow, I won't make a mistake, rather than strategically. Strategically versus just slow. There's a difference. I see that. I hear where you're coming from on that. Absolutely. I mean, as far as everyday people and detail and attention puts in the case, I get it. And it's going to depend on I say this carefully, it will depend on your jurisdiction. It's a special job to be a prosecutor or to be a court-appointed defense counsel or defense counsel. It takes special work because each case that you're working on, that's your whole world. And it doesn't matter who it is. It could be any kind of case, any level of case, because there are going to be people harmed if you're not doing it correctly. So, just by the amount of time that I've spent with prosecutors, as well as going to and hanging out with defense counsel, they put in the people that I have worked with, that I have been around. Each case is important. Every case is important. Is every case on fire? No. So the ones that are on fire, of course, get the most attention. But, we don't measure a case by publicity on how important it is. There's usually, if there's a victim involved, we're trying to go and seek justice for that victim. Or if we're defense counsel, we're trying to make sure that our client was given all their constitutional rights. That's the goal. Were all of their rights accommodated. But you better believe in these cases that everybody is looking at it under a microscope. So every attorney in all of the Trump cases, as well as the judges, you are absolutely right. They are looking at this so carefully because it is the former president. So you're absolutely right about that, I would say. I've not seen the Karen Reed trial out of Massachusetts. I've not seen that. It's hard to keep up with, because there's a lot of stuff going on right now. There's a lot of stuff going on in the legal world at the moment. I even saw, oh my gosh, everybody. Speaking of keeping up on everything, we've got letters sent out to the Chief Justice regarding ethical violations from Thomas and Alito. There's stuff, and there's a resolution that's been put together on censuring Justice Alito. There's a lot of stuff going on right now. It's a good one. I'll take a peek at it for sure. But yeah, there's a lot. There is a lot of stuff going on. And this may be, everybody, the time where we see those newly minted ethical rules that the Supreme Court has said that they'll follow. This may be the moment that they need to take it into consideration. Does the prosecution really get to withhold exculpatory evidence unless you go to trial? So, all right. So the process, it doesn't quite work that way. The process isn't if we go to trial or if we don't go to trial. The process is along the way. So along the discovery route, you have to meet your time zones and you have to exchange evidence. So if I guess it's hard for me to really to explain it better than that. You go along according to what information that you have and is given to the other side. But that's based off of the timing on everything. That's not how it's worked here. Now, the other thing too, Easton in Maricopa, I cannot speak for all jurisdictions. I simply can't. Even within my state, I worked in multiple counties, and there were differences depending on which county I was working in, out of the different offices. And that same level of commitment, that compassion was there across the board in the state, in the jurisdiction I work in, but it's not going to be that way for everybody. Even, I would say, the next state up, the state that's north of me, I went and did training up there, and it's a different ball game for sure. Unless it goes to trial, they will not release it. Well, and that's interesting. So, we have the Brady rule, which means you have to give exculpatory evidence over to the other side. But see, there's lots of points at which there's exculpatory evidence. There's lots of points. So, do you give them exculpatory evidence, when they're arrested? Do you take it to them that night? How long do you have to research and make sure that the exculpatory evidence is really exculpatory? The preliminary hearing? You know what I'm saying? Do you wait until they get appointed an attorney so you can talk to that attorney about that exculpatory evidence? There's just so many things along the way. So it's not it's not as clear cut as that. And I'm not trying to dance around the issue. My belief is if there is exculpatory evidence, it should be given to the defense. But rules have to be followed as to timing of that. We've asked for it and had them put it on the record that they're not handing it over. That's interesting. That's, I don't know. That sounds hinky to me. That sounds hinky. We have to be careful. Love the bling on the left. Thank you very much. Yeah, I guess for me, I felt if there was exculpatory evidence, then why is somebody charged? I mean, I would dismiss the case myself if there's exculpatory evidence. I don't know why I would be like, I've got evidence that proves you're innocent, but I'm going to keep going forward on your case. Like, no, I will, as the prosecutor, I will file a motion to dismiss because I have evidence that says you didn't do it. So it's kind of, that's why I'm like, I'm not sure exactly what's going on with that. Lawyer. Yeah, so, right. But again, I mean, I just can't, I'm not in the, for me, I cannot put myself in a situation where I've got evidence that proves the defendant didn't do it or did a lesser charge and not immediately take action on that. But I'm also no longer a prosecutor either, everybody. To go to court before counsel. I know you have to go to court before counsel's appointed. Exactly, Neva Bet. Right. Yeah, you've got to go in and have counsel set in. Oh, you bet, Cody. Good to see you. California, where they had the evidence, but after they set the court date. So, yeah, I mean, but again, that's not how it should be. I can't speak for all attorneys. I can't speak for everyone's ethics, but for me, if I had, when in doubt, I would prefer to dismiss a case and refile it later than to have an innocent person be charged. But that was how I went after it. I could explain it to you. Yeah, I know. Got to court and they dropped the case. Yeah, that should never be. You shouldn't. Yeah, and that's a stinkeroonie. All right, everybody. I wish it wasn't that way. I wish it wasn't. But yeah, I mean, there were many times where I had cases where people were arrested and I got the police report. I did my own research and I went in and I'm like, we got no case here. Rights were violated. I'm not even going to go through a motion to suppress. Like, we're done. This case is toasted. Known for its ethics. Well, yeah, and that's the thing too, is it will vary depending on where you're at. And, even probably within the county in Maricopa, because it's so big, even within that county, it's going to vary as well. Yeah. Yep. But also, I was in a position where I could do that, but not everybody is. So I never felt like I wanted to do or say anything and do anything in a way where I couldn't just walk away. I guess I never made a bet that I couldn't follow through on, is how I always did it when I gambled. And really, when you're making plea agreements or you're going through the criminal system, there's a lot of gambling. And I would never make one where I couldn't walk away. Getting a conviction via a plea, then acknowledging innocence. Right. And I mean, that's a systemic issue. That's a systemic issue that, it would be wrong of me to say that that's not an issue. It just is. Yes. Thank you everybody for joining me and my fun Q&A for tonight. Sound advice. Well, right. Absolutely. And it's unfortunate, but I think it is getting better. But, yeah, it is. Yes. So at this point, everyone, let me go ahead and give you my overview. I am planning to come back tomorrow. I know that it's Memorial Day for everyone. But for me, my 7 o'clock time should be open because, again, Central, because of what my schedule is. So I am planning to come back again tomorrow. And I'm not sure exactly. I've got a couple different topics I'm thinking about doing. So I'll have to figure out which one I want to do at that point. I, again, need to do an update on Florida. I've got some interesting things going on there. So, thank you so much, everybody. So I'm hoping to come back tomorrow, 7 o'clock. As for the topic, I'm not 100% sure. But I'll be diving back into my normal 7 o'clock Central. We'll have my comments on for everybody for the next few days. So should be back up and running. Yes, I hope everyone has a wonderful Memorial Day today or tomorrow. Be safe, everyone. And remember the people you need to remember. For sure. But we do have a lot of things coming up in the legal world, everyone. So I will be staying on top of it, especially in Florida. We've got some interesting things going. And be safe at the fireworks. Oh my gosh, Suze, yes. Hope to see you tomorrow. Absolutely. Yes, and my cats. I'll have to hug my cats. Yes, for sure. And I will say right now, everybody, I will be doing some lives on Hunter Biden. His case is so fascinating. I could not pass it up. So his motions in limine are just like spicy firecrackers. So I will be back to go through that. May not be back to, oh, no worries, Navy vet, no worries. I will, of course, be putting it up on my tube of you as quickly as I can, everyone. So wishing you all the best of nights, and I will be back again tomorrow. So take care. Thank you, everyone, for coming and hanging out with me tonight. I'll see you all tomorrow. Thank you. Bye.